All right, good afternoon, everyone. Welcome to the City of Madeira Beach Code Enforcement Hearing. My name is Bart Valdez, and I am the appointed special magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 20 years. I've been appointed to this position in accordance and with the authority set forth in Chapter 162 Florida statutes. It is my role to fairly and objectively review these matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. Every effort will be made to hear all persons having relevant evidence, argument, or comments to offer related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in by the city attorney in just a few moments. In all cases, since the city has the burden of proof, the city will present its case first. Respondent or property owner then will be given the opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing and will be sent to the landowner. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated and to provide you a reasonable time to correct the violation by whatever means is available to you. Please be advised that you may be subject to a fine and a lien may be recorded on your property if the violation is not corrected by the compliance deadline. If you wish to present any information to me today, it is necessary that you swear or affirm that you will tell the truth. Therefore, at this time, I'll ask the city attorney swear in any witnesses. So anyone who wants to talk to me today, you need to rise and raise your right hand.
You'd stand up, raise your right hand. Swear the testimony you're about to give today is going to be the truth, the whole truth, and nothing but the truth? Yes, sir, I do. All right, thank you.
All right, the first matter before me today is case number 2024.3730 for the property located at 121 129th Avenue East. Is the city ready to proceed?
We are.
Go ahead, Mr. Trask.
The city would call Grace Mills as our witness in this case. Grace, if you could tell us what your occupation is and your job responsibilities here at the City of Madeira Beach.
I'm code compliance for the City of Madeira Beach. I deal with violations, lack of permits, and also the permitting system for the building department.
Okay. Are you familiar with this property that the special magistrate just read the address on, 121 129th Avenue East?
I am, yes.
And this is a code case that's being brought before the special magistrate. Was this a proactive case or was it complaint-driven?
This was proactive.
Okay. And when did you first go out to the property?
Scroll down to that. It's first in January of this year.
Okay. And who's the owner of that property?
Per the property appraiser and tax appraiser's website, it appears to be an NJE Properties, Inc.
Okay, and looking at page 3 of the packet, 3, I guess it's 3, 4, and 5, maybe including 6. This is the printout from the Pinellas County Property Appraiser's website?
Correct, yes.
And it does reflect that the owner is NJE Properties, Inc.?
Correct, yes.
And you also printed out the printout from the website from the tax collector, correct?
That's correct.
And what pages of the packet are that?
It'd be page 7.
Okay. And it does it reflect the same owner?
Yes, NJE Properties, Inc.
Okay. And does it reflect the same property address?
Yes, it does.
Okay. So when you went out to the property in January, what violation did you find at the property?
The sign on top of the business had been replaced from what it priorly was, and there was no permit for it.
Okay. So did you happen to take a photograph of the sign when you were out at the property that day?
I did, yes, and that's reflected on page 10.
All right. So is this the page 10 that you're pulling up the photograph?
Yes, the first sign with the ice cream on it is the one in question.
Okay. Just it's attached to the roof line?
Yes.
Okay. So how did you determine that that particular sign was not properly permitted?
I had gone back, let's see, on page 12, that is the Google Street View from January 2023, and it reflects a different electrical sign. And since that had been changed, no permits have been obtained.
Did you check the permitting department to determine whether a permit had been pulled?
Yes.
Okay. So did you issue then a courtesy notice of code violation in January?
I did, yes.
And who did you send that to?
That was to NJE Properties, Inc.
And how did you send it to them? By regular mail?
The first letter was regular mail, yes.
All right. And when it was sent, did you get a response from the property owner?
We did not, no.
All right. So Did you follow up then with well, first of all, let's talk about the courtesy letter itself. It starts on page 8 of the packet, and if you could go through that letter and explain the letter itself, when did you actually sign it?
Sure. It was sent January 31st, 2024, citing the ordinance 10246 for required of the sign that had been changed. And it was actually sent on January 31st, 2024 and signed. This copy, however, does not reflect the signage. However, the sent one was signed.
Okay, and let's talk about the code section 102-46. You've referenced subparagraph C, which provides no person shall erect, construct, maintain, alter, relocate, demolish, repair, or paint, or do any work upon a sign for which a permit has not been obtained. Are there any other code violations that were cited beside that particular one?
No, that is the code section that was cited for
Okay.
this.
Did you give the property owner a sufficient enough time to bring the property into compliance?
Yes, our follow-up date on this letter was February 14th before the certified letter was sent.
Okay. And attached to that letter was what?
Attached to the letter were the photos that reflected the signage. Is that what you're asking?
Yes.
Okay.
So on page 10, then, it shows the photograph that you just mentioned a few minutes ago.
Yes, on the roof line for the front,
And what does page 11 reflect?
the back of the signage that you can see on the roof line as
Okay.
well, just the front and back.
And then on page 12 of the packet?
Yes, that reflects the sign that was there January 2023 via Google Images.
And is that the sign that says the sandbar?
That's correct, yes, in the same place on the roof line.
Okay. So did you hear from the property owner before February 14th, the compliance date?
From the property owner?
Yes.
Not before the compliance date, no.
Okay. Did you hear from anybody else before February 14th?
There are current renters that are on the property that made communication with us, yes.
Okay. And did they follow up then and obtain a building permit?
They applied for an application. The application is still pending as of today's date, has not been completed.
And when was that application filed approximately?
It was approximately March of this year.
And what is remaining for the building permit to be issued?
As of right now, a few documents, the building official needs signed and sealed plans from a contractor would be the first start, reflecting the signage change.
Okay. So it was pulled by the property owner who is not from the tenant who is not a contractor?
Correct.
And were there any plans submitted with the application?
There were not.
Okay. So did you issue then a notice of code violation?
I did, yes, on March 5th, which is reflected on page 13.
Okay. It's very similar to the courtesy letter that you had sent previously in February or January?
Yes, it's the exact same. The follow-up date was just moved to March 19th as a second follow-up.
Okay. As of today, though, there's been no building permit that's been issued for this sign, correct?
Not obtained and issued, no.
Okay. And this letter that we're talking about now, was it sent by regular mail and certified mail?
The second one, yes, regular and certified.
Okay. On page 19 of the packet, it shows a green card that's been unexecuted. Is that when you first mailed it?
Yes, that's correct.
Did you get the green card back?
We never got the signed card back, no.
Okay. Did you hear from the property owners after this letter was issued?
Yes, they did make contact, letting us know that they informed the tenants that what would need to be fixed and that it would be addressed.
Okay. Have you heard from them since that time?
Not the property owners, no.
Okay. So did you then issue a notice of hearing for today and also a statement of violation and request for hearing?
Yes, that's started to reflect on page 20, which was sent September 13th of this year.
All right, so let's talk about page 20. That's the affidavit of service,
Correct.
and that reflects that you sent a copy of the notice of hearing by certified mail, by first-class mail, that you posted it at the property, and that you also posted it at the municipal government offices at 300 Municipal Drive. That's City Hall, correct?
That's correct.
Okay. And then the notice of hearing followed up on page 22 and 23. That was what was sent by those ways that I had just mentioned?
Yes, the
Okay.
regular mail, certified mail, and posted at both properties.
All right, let's talk about the statement of violation, which is on page 24 of the packet. That statement of violation reflects the same code section that we had been talking about earlier in your testimony.
That's correct.
There's nothing that has changed on the property since that original courtesy notice has happened, correct?
Correct.
No other violations are being cited.
Correct.
Okay. And that also is showing that in the packet, the green card on page 26, that's the one that you actually mailed. Have you received, that's the one you actually mailed, correct?
Yes, that's correct.
Okay. Have you received the green card back?
We have not received it back.
Okay. Have you heard from the property owner since you had sent this, the notice of hearing and the statement of violation?
The property owner, no.
Okay. All right. I'd like you to turn to page 28 of the packet, and if you can explain to me what this picture depicts.
This is from the date that the property was posted, which was September 13th of this year. If you look in the middle column, that reflects the actual posting, which was certified mailed, regular mailed, and posted at the property and City Hall. That's just proof that it was posted that day.
So it looks like a piece of paper taped with red tape?
Yes.
Okay. All right. And then on page 29 of the packet, what does that photograph reflect?
That reflects the actual documents that we spoke about earlier being posted at City Hall on September 13th of this year.
Okay. And on page 30 and 31 of the packet, can you explain what those photographs depict?
30 is reflecting the back of the signage, and 31 is reflecting the frontage, which was taken, updated September 13th of this year, just to reflect that it's still standing.
Okay. This last two photographs reflect some type of lighting that has now been attached to the top of the sign. Do you see that?
In 31, I do, yes.
Okay. Is that solar lighting, or is that electric now that has been added to the sign after they were told that they needed a building permit?
I can't speak to that, I'm not sure.
Okay. So as of today, the property is not in compliance?
Correct.
Okay. How much time do you think it would, well, first of all, what would it take to bring the property into compliance? What are the options for the property owner and the tenant?
They can keep the current signage as is if we get the required documents into the permit and it's approved and active. They can keep it, or they can remove it. They would not need a demo permit to remove. Removal of the sign would take care of the violation.
Okay. How much time do you think is a reasonable period of time to bring the property into compliance?
I would say 30 days to bring it into compliance.
And if it's not brought into compliance within that 30-day period of time, what are you asking the special magistrate to order as to the daily fine?
The city would ask for $150 a day if not brought into compliance.
Okay. All right, I have no other questions for Ms. Mills. I would tender in the evidence, though, pages 3 through 31 of the packet, ask that they be received.
All right, we'll go ahead and accept into evidence as exhibit number 1 to this hearing, pages 3 through 31. Is there anyone here today on behalf of NJE Properties? You here on behalf of NJE Properties, sir?
Not exactly.
All righty.
Tenant.
Okay. Mr. Trask, I'm going to defer to you on whether the tenant would be entitled to cross-examine.
I don't have an objection to that.
Okay.
Yeah.
Sir, why don't you come on up here, give me your name and your address and relationship to the property.
Dustin Griffin, 121, 129th Avenue East.
All right. And what's your relationship to the property or the owner?
My corporation is a tenant.
Okay. All right. Sir,
And
I'm going to give you an opportunity to tell me whatever you want to tell me. If you want to ask Ms. Mills any questions, this is your opportunity to cross-examine her. You saw what Mr. Trask did. You don't have to ask her any questions, and again, I'm going to give you a full opportunity to tell me anything you want to tell me, but do you have any questions for Ms. Mills?
Not that I haven't already talked to her about.
All right, great. Don't go far. You might be up next. Mr. Trask, does the city have anyone else?
We have no other witnesses today in this case.
All right. Mr. Griffin, what is it you'd like to tell me about this violation? This is your opportunity to provide me any photographs, call any witnesses, or just tell me your thoughts on this violation.
I was just going to tell you my thoughts. Grace posted notice on the building back in the earlier part of the year. because I didn't get any of those certified letters because they were going to the landlord. So we weren't aware of the violation. Because we did that work, this is 2024, so that would have been early 2023, the spring of 23, around April, May, that time frame. So we found out about this the early part of this year when it was posted. And I put my wife in charge of getting a hold of Grace and figuring out what needed to be done to bring it into compliance. And I guess Grace had requested some stuff, Chrissy had sent it to her, and we just didn't hear any more back. Apparently there was an email sent that didn't get looked at or went into spam or whatever. So I hadn't heard anything, so I thought whatever Chrissy had provided was good enough. It was taken care of, hadn't heard anything, until Grace, a week or so ago, posted that second notice. And that's like, whoa, this hadn't been taken care of. So what do we need to do? So Chrissy's been in touch with Grace to find out what we need to do to bring it into compliance. And even though that, you know, the notice said, no person shall erect, construct, maintain, alter, or relocate or demolish, I haven't touched it since because I didn't want to demolish it without permission. But right below it, it does say to bring the property into compliance by applying for and obtaining an after-the-fact building permit or removing unpermitted work. Well, it was unpermitted. I didn't want to go mess with it until I had permission from you or yourself to touch it. But I could go have that taken down pretty quick. I just didn't want to do it and cause any further problems.
Okay,
But we did reach out to two sign companies. Extreme Signage over here in Seminole was one of them. I'd reached out to them last year, never heard back from them. They said they were going to come out, and they haven't been out yet. I don't know if they're coming. And another St. Pete sign company who gave us a pretty high estimate to come out and obtain a permit, get what we need to get this thing permitted as is, but they haven't showed up yet. But I am prepared to go take the sign down and make this go away until we're able to obtain a correct permit and get it re-put back up.
all right, Mr. Trask, do you have any questions for this witness?
Just a few questions.
Yes, sir.
So you don't disagree that a permit has not been obtained, correct?
Yes, sir.
Okay, and you don't disagree that some type of lighting was added to the sign after the original notices went out saying you need a permit for that sign, correct? Lighting was added to the
I'm
sign.
not sure when that lighting got added, but I was the one that added it, but just don't remember when I added it.
Okay,
So I
and
can't speak to that because of my memory. I just don't remember when it was done. But again, we had that long period of silence where I thought everything had been taken care of.
okay,
So now that I know that it's not, I'm here
so is that,
to rectify that.
thank you. Is that solar lighting or is it electric?
That is plugged into an electrical outlet.
Okay. And so did you obtain a permit for the electrical work that was done on the sign?
There was no electrical work done other than plugging it in.
Okay,
Meaning that it's the kind you plug in, not the kind you have wired. And there is already a plug there that we simply just plugged it into.
okay. How much time do you think it'll take for you to take the sign down to bring it into compliance? I'm
Maybe
sorry?
once I start a day.
A day, okay. So if the special magistrate gave you a 30-day time frame, you would absolutely have it completely removed from the property,
Yeah,
correct?
absolutely.
Okay,
And I could even notify Grace when it's done, because she wants to come out and take pictures and that bit. But I did want to add, what I told Grace before we started was that when I signed the lease, the existing tenant was still in the premises and had 4 signs. You saw at least 2 of them. The one that was, this one replaced, the big giant billboard, a mural on the side, and an electrical sign on the back. Well, once I moved in, I realized all those signs had been removed. And this one in question had a big piece of wood that was hanging from the sign. When they removed it, they just left it hanging. The board and the frame that was holding up that previous sign had fallen. And the neighbors had told me, yeah, you can replace that because it's rotten wood and is a danger to people. So I replaced the rotten wood, but I went an extra step beyond that in replacing just the frame and put up that piece of plywood there. And then I put that vinyl banner over top of the plywood. And sometime more recently, since then, I lit it, so it would show up at night.
I have no other questions. Thank you.
So that's why we did it, because I didn't think it needed a permit, but that was my mistake.
All right, well, thank you, sir. That's all I have. You can go ahead and have a seat.
Thank you, sir.
All right, this is the time in this hearing where if there's any members of the public that would like to provide comment, they may come up. Let the record reflect there are no members of the public here, so we will go ahead and move on. Anything else, Mr. Trask?
I would just like to provide you with the actual code, so the entire code section 102-46, ask you take judicial notice of that code section. And also a printout from the website from Sunbiz, ask that you take judicial notice of that as well, reflecting the address of the property owner, NGE Properties, Inc., through Sunbiz.
All right, I will go ahead and take judicial notice of both the code section as well as the Sunbiz printout. Do you want me to attach them as exhibits to the hearing as well?
I think that would be a good idea to go ahead and do that.
Okay, we'll do exhibit number 2 will be the section 102-46, and exhibit 3 will be the Sunbiz printout that shows the current registered agent and mailing address for the owner.
Thank you.
Okay, based upon the testimony that was provided to me, as well as the admission by the tenant that the violation does indeed exist, I'm going to go ahead and find the property is in violation. Sounds like 30 days is a sufficient time for the respondent to come into compliance. Thereafter, that'll be a $150 a day fine if the property's not brought in compliance. Sir, once you get that sign down, please let Ms. Mills know so she can go ahead and file the appropriate paperwork. Otherwise, there will be a fine that starts accruing after 30 days. All right, let's move on to the next case, which is case number 2024.3738 for the property located at 14268 North Bayshore Drive. Is the city ready to proceed?
We are.
Go ahead, Mr. Trask.
The city would call Grace Mills. Grace, what is your occupation and your job responsibilities here at the City of Madeira Beach?
I am Code Compliance Officer for the City of Madeira Beach. I deal with permitting, lack of permits, and the permit process for the building department.
Are you familiar with this property at 14268 North Bayshore Drive here in Madeira Beach?
I am, yes.
Okay. And is this a proactive case, or was it as a result of a complaint?
Proactive.
Okay, and was this something that you found as a violation, or was it brought to your attention by someone else in the city?
It was brought to my attention from our building official, Frank DeSantis.
Okay. And what did Mr. DeSantis provide to you as a basis for you to go out to the property to review it?
Let me, photographs, which are reflected on page 40 and 41 in the packet. 40 reflects, as of December 2022, what the exterior wall looked like, and Mr. DeSantis had noticed, which was reflected on page 41, on February 19th of this year, electrical that had been added, and there was no permit for the address.
Okay, so did you go out to the property to take a look at it?
I did, yes.
Okay, and did those two photographs accurately depict what you saw when you went out to the property, or at least the electrical portion of it, the newer photograph?
Yes.
Okay, and so who is the property owner,
Let me get back up to that page.
and how do you know that?
We'll start on page 32 of the packet. Reflects Anthony Karras as the property owner, and that is from the property appraiser. And if you follow down in the packet to page 36, this is the tax collector for Pinellas County, reflecting the same address and the same homeowner.
All right. So after you went out to the property to see the electrical work that's been done, did you issue a courtesy notice of code violation to the property owner?
I did, and was dated February 19th of this year.
Would that have been around about the time that you actually went to the property?
Yes.
Okay. And when you issued the courtesy notice of code violation to Mr. Karras, what were the ordinances that were being violated?
With section 8652, when required, is the ordinance that was violated.
And what does that particular code section require?
That requires permits for work within the code that would be electrical over a certain amount of money, which both were. So it reflects the need for the permit for the work.
Okay. When you sent this letter courtesy notice, did you send it by regular mail and certified mail or just regular mail?
This first courtesy notice was regular mail.
Okay. And does it reflect a follow-up date or a date of compliance?
It does on March 4th of 2024.
In addition to the compliance date, did you also attach photographs of the property?
I did, yes, that was reflected on page 40 and 41.
Okay. And how did you get the photograph that is shown on page 40?
That was from Google Images, which was dated December 2022 of the property.
Okay. And then the photograph on page 41, you mentioned that this is what it looked like when you went out to the property?
Yes, and that was February 19th of this year. That was what was seen at the property.
Was the property brought into compliance by March 4th?
Was not.
Okay. Did you issue a notice of code violation then?
I did on March 5th of this year was our code violation that was sent by regular and certified mail.
And is that reflected starting on page 42 of the packet?
That's correct.
Okay. When you prepared this notice of code violation, did it include the same photographs as the previous courtesy notice?
It did, yes.
So it's basically the same, it was just an updated compliance date, correct?
Correct.
So what was the compliance date you gave him, the property owner, in your notice of code violation?
March 19th of 2024.
Okay. And you said that was sent by certified mail?
Correct.
And is that green card that's reflected on pages 46 and 47, is that the green card that went with the letter, or the notice?
Yes.
Have you received that green card back?
We did not, no.
Okay. Have you heard from the property owner since either the courtesy notice was sent or the notice of code violation was sent?
From the property owner himself, no.
Okay. Did you hear from somebody else?
I have not directly, however, Holden Pinkard has spoken to the brother. His name is Larry Carras as of this year, or excuse me, as of the 13th of this month. He has had communication with the brother.
Okay. And what was the substance of the conversation with the brother?
The brother relayed that the owner has health-related personal matters, that he's not able to take care of this at this moment, and Mr. Pinkard explained the issues of the violation and what was needed to bring it into compliance.
So did the brother understand then that he needed to get a building permit to have this done?
Correct, yes.
Okay. And has the brother then obtained the building permit from Mr. Karras?
We have had no further updates since Mr. Pinkard relayed the information. We have had no application submitted either.
Okay. So did you issue then a statement of violation and request for hearing?
I did, yes.
And on page 48, it was reflected the statement of violation request for hearing. It's 2 pages long. It looks like the notice of hearing is on pages 50 and 51. You agree that those would depict what those documents are that I just mentioned?
That's correct, yes.
Okay. And you also have an affidavit of service on pages 52 and 53?
Correct.
So that affidavit of service reflects that you sent the notice of code violation by certified mail, regular mail, you posted the property, and you also posted it at the municipal government offices at 300 Municipal Drive, that's City Hall again, correct?
Yes.
Okay. Have you got the green card back for that?
We have not received that one either, no.
Okay. But the green card that was sent was on pages 54 and 55 of the packet, correct?
Yes, that's correct.
All right. What does page 56 reflect?
Page 56 reflects that on September 13th of this year, the property was posted with those documents we had just gone over.
Okay. And then on page 57, what does that photo reflect?
That is the posting at City Hall, as mentioned in the affidavit of service.
And the photograph on page 58?
Page 58 was the 17th of this month, reflecting that the electrical work is still in place at the property.
Okay. As of today, the property is not in compliance, correct?
Correct.
Okay. How much time do you think that it would take to bring this property into compliance?
30 days.
What would it take to bring it into compliance? What are the options?
Either removal of the electrical work whatever the extent may be that was done, or properly permitting with an active and issued permit.
Okay. And how much time do you think is a reasonable period of time?
30 days.
One question I failed to ask you when you were talking about the brother, did he contact the city as a direct result of receiving one of the notices from the city?
I believe from the property being posted, yes.
Oh, the property being posted. Okay. All right. So 30 days to come into compliance, and what is the dollar amount of the fine that you're seeking from the special magistrate?
The city would ask for $250 a day if it does not come into compliance.
And what is the reason for the $250 a day fine?
With it not being permitted in electrical work, the city would see for life and health safety issues.
Okay. All right, thank you. I don't have any other questions of Ms. Mills. I would like to tender into evidence pages 32 through 58 of the packet, and also like to provide a copy of the entire code section 86-52 and ask that it be, you take judicial notice of that code section. And I have no other witnesses.
Okay, we'll go ahead and accept into evidence as Exhibit Number 1, pages 32 through 58 of the agenda. Also go ahead and mark as Exhibit 2 the code provision dealing with this particular violation. This would be the part of the hearing where the respondent or anybody on behalf of the property owner could appear. Don't see anyone. If there's anyone here that can hear my voice that wants to come in on behalf of the property owner for the property located at 14268 North Bay Shore Drive, please step forward. Okay, seeing none, I'll go ahead and move on to public comment. Again, let the record reflect there are no members of the public in the chambers today. Therefore, I'll send it back to you, Mr. Trask. Is there anything else you want to tell me in regard to this particular violation?
No, I just think that it's obvious from the photographs that there has been electrical work done on the property as reflected in the photographs. There is no building permit that has been obtained. The property can be brought into compliance by either removing the electrical work on the building or obtaining a building permit. The city is requesting that you provide the property owner 30 days to come into compliance, and if not in compliance by 30 days, to issue a fine of $250 a day for each day thereafter that the property remains in noncompliance.
All right, based on the sole evidence before me, I do find that the property and the owner are in violation of Section 86-52. Therefore, I'm going to go ahead and determine that 30 days is a reasonable time for the respondent or owner to bring the property into compliance. If the property is not brought into compliance within 30 days of today's hearing, then there will be a fine of $250 per day that accrues on the property. All right, Mr. Trask, anything else before me today?
No, that's it for today. Thank you.
All right, thank you. That concludes today's hearing.